Hi, thank you for joining us on this webinar to review various issues that we think the charitable community may need to know about as they approach different ways to run their organizations and perhaps to respond to some of the many pressures presented through the COVID virus situation we're all in. My name is Beth Short, and I'm with the Ohio Attorney General's Charitable Law Section. Joining me today for this discussion is one of our Assistant Attorney Generals, Abby Jacobs, as well as the Assistant Chief of the Charitable Law Section, Matt Halandani. So thank you for joining us, and I want to make you aware of the fact that we have prepared a number of resources that appear on the Ohio Attorney General's webpage under Resources for Charities that go through a number of operational best practices that we have suggested for charities. For instance, Ohio nonprofit law allows boards to meet by Zoom, Skype, and other telephonic methods unless their bylaws specifically prohibit it. So charities need to continue working, continue to do the governance work, and be very strategic about how to respond in these challenges. It's also important to make sure that you're continuing with your internal control processes, protecting your resources, protecting mail that may be coming in that contains checks for your organizations. So now is not the time to sit back if you're a leader of a charitable organization. Only the very nimble and adaptive organizations are going to be able to easily survive this situation. And so we've put up a number of resources, best practices, take a look at them, stay up to date on what's happening with the coronavirus situation, as well as any sort of relief programs that are out there that charities are eligible for. And we want to help make sure that we still have a thriving charitable sector in Ohio once we get through this health emergency. So one of the things that we wanted to talk about were a number of special situations that may present themselves for Ohio charities as a result of these pressures. And we're going to start with the bad news first. We know that the coronavirus situation has had a harsh impact on businesses throughout the country. And in fact, some businesses are not going to survive. And the same can be said for charities. There are many charities that will not survive the financial stresses that this situation has created. But there are specific things that board members need to think about if they decide that going out of business is what the organization needs to do. There are certain best practices, certain requirements, and we want to make sure if that is what is facing your organization, that you're mindful of doing it the right way. Abby, what are some of those processes, procedures, and issues that boards ought to be sure that they're thinking about if closing down and dissolving is what needs to happen?
Sure. So I'll start with our expectation, and our expectation and the law's expectation is that the board has been involved in monitoring the group situation and that they are regularly meeting to discuss the best steps and what is best for the organization. So we know that deciding to close the charity is not something to take lightly, and we expect that boards also know that and that they're treating this decision with the utmost care. So once a board has gone through this process, has watched what's going on with the charity and made the decision to close, the board's obligations don't end there. There's a lot left to do. So the board first and foremost needs to take a vote to actually dissolve the organization, and then needs to make decisions about who's responsible for winding down the charity's activities. And that includes distributing the assets, closing the bank accounts, filing the dissolution documents with the Secretary of State, filing a final 990 with the IRS, filing a final annual report with our office, the Charitable Law Section. So there's a whole bunch of stuff to do even after you make that decision. And then there are some important things to think about. So it's important to know that it's a breach of your legal obligations to just abandon the charity. Boards must remember that they just can't do whatever they want with whatever money is left. So if you do have some money left and you're going to distribute it, you can't just do whatever you want. You certainly cannot give that to the board members and the officers. So the assets must be accounted for and distributed, and they need to be distributed according to the organization's governing documents. And boards need to be having meetings about this and writing meeting minutes and making sure they're documenting all of this. And so there's all sorts of things to think about. And one of those things particularly is where the money needs to go. And so the money must go first and foremost where the articles and bylaws and governing documents say. But second, you also should look to Chapter 1702, which specifically lays out what happens if your articles and bylaws don't say where the money should go, or that's no longer possible. So that's somewhere you should definitely look.
So you're saying that in the governing document of charitable organizations, whether it's their constitution or their bylaws, it might say that if this organization needs to go out of business, all assets should be transferred to some sort of maybe a statewide organization or a similar organization. Is that a common provision in some of those documents?
Yeah, so there's often boilerplate language in organizations' governing documents that say that upon dissolution, it must go to another 501c3 or another governmental entity, for example. And 1702 also specifically says that it must be applied to a purpose similar to the purpose in your articles of incorporation. So you're not really, in Ohio at least, you can't just give it to any 501c3 or any governmental entity. You really are supposed to try to stay close to the purpose for which your organization was created and exists.
Well, that seems fair, since donors were giving to a particular cause that was important to them, that even if that group doesn't survive, it goes to another group doing the same sort of work. And you've talked about money, and if there's money in the bank account, about how to distribute that. But for some groups, it may not be money, but a lot of equipment and goods. Do the same sort of provisions apply to computers, lawn equipment, that sort of thing?
They do. So all of the assets of the organization need to be used consistent with the charitable purpose and consistent with your governing documents. So that can be either donating those assets to a similar charity, or it can be selling and liquidating those assets and then giving that money to a similar charity.
Can they just give those kinds of goods and equipment to staff or board members?
They certainly cannot. No.
So if they make it available to those interested parties, it would be okay to sell them as long as it's being sold for a fair market value, correct?
That's correct.
So those are still charitable goods up until the very end, and the mission still needs to benefit from it, is what you're saying.
That's right. We say in charitable, once charitable, always charitable. They don't become non-charitable just because the organization closes.
And you mentioned that there are specific forms that have to be filed with our office when an organization is going out of business?
Yes, so and organizations in Ohio, charities have to register with our office. And so when the organization ceases to exist, it has to file a final annual report with our office. And so they can do that through the online registration system, just like they fill out all of their annual reports. Or there's a specific form on our website that they can choose to fill out in lieu of doing it the way they always do.
And so that filing will also give us a chance to, if we have questions in the charitable law section, that filing will allow us to assure ourselves that the resources did indeed go to a charitable purpose, correct?
That's right. The form includes a bunch of information that's relatively easy for the charity to fill out, but also helps us know what happened to the money, specifically where the remaining money went and who was holding the records of the organization.
And then they're going to need to file things with the IRS and the Secretary of State as well to let them know they're going out of business.
That's right.
Now, some groups may not go out of business, but they may end up partnering and merging with other organizations that may do similar work or important services in the same geographic area. Every time there's a downturn in the economy, a number of people project that a number of mergers may occur in the charitable sector. In 2008, during the economic crisis that we went through, many people projected a lot of mergers, and it didn't really happen that way because mergers can be very difficult and can be hard for groups to come together and reach a common understanding of operations. What is the process legally? What happens when two charities decide to merge?
So that's a complicated question, but in Ohio, nonprofit corporations can choose to combine into a single organization in two different ways. They can either merge or they can consolidate. So in a merger, one organization is actually dissolved into the other organization and transfers all of its assets into that surviving organization. And so in that situation, the organization that is ceasing to exist and merging into the other organization will have to do all of the dissolution things we just talked about. And so all of those requirements come into play here. In a consolidation, the two separate organizations actually create one new organization. And so in that situation, both of the organizations are ceasing to exist and have to do all of the dissolution paperwork and requirements that we just talked about. But if two organizations decide to either merge or consolidate, it doesn't matter. There are some things that the organizations need to think about. So first and foremost, the organizations need to agree ahead of time that this is what they want to do, that this is what makes sense, and how it's going to work. So there are expectations they need to think about in advance. And some of them, and certainly not all of them, include how will staffing work? Who will continue to be employed? If there are employees, will they continue to employ everyone from both organizations or just one organization or a combination? Will programming activities change and how? Will the mission be expanded or changed? Do they need to change their governing documents as a result of this? Does the surviving organization want to change its name or add a DBA? And as you can tell, many of these types of changes will need to be filed with the Secretary of State, and the IRS, with the Attorney General's office, with your banks. They'll need to know your new names or DBAs. So you want to make sure you're communicating all of that information if you're making those changes. And then more information about mergers and consolidations can be found on the Secretary of State's website. That's where you'll actually do the corporate parts of it. And so if you're actually changing the corporation, you do that through forms with the Secretary of State's office. And then one last complication to this, if it is a 501c3 organization that is merging with an organization that is not a 501c3, there are notification requirements with our office. And that's a relatively complicated process that we don't need to get into here because it's pretty rare. But if that's your situation, reach out to us and we'll talk to you about it. And you can always look at the statute 1702.41.
Seems to be that there are a lot of what can be complex issues in merging organizations because it involves property issues, contracts, debts. And so for that reason, I'm guessing many organizations have lawyers assisting in this process. Is that correct?
Yes, I've never come across an organization who's merging who didn't have an attorney involved.
Sometimes when we're facing challenges and we're with a charitable organization, rather than going out of business or merging, one of the things that some groups end up doing is selling off some of their assets or maybe some of their properties or even spinning off some of their programs in order to inject additional cash into the organization. Are there issues that they need to be mindful of if they're considering those kinds of transactions?
Yes, so charities need to know that there are potential notification requirements with our office. So the magic number is 50%. If your charity is getting rid of 50% or more of its assets in a 3-year period, in one transaction or a series of transactions, then you have to let us know. And once you let us know, there's a whole process that happens after that. So you have to fill out a notification form at least 20 days before that sale or other disposition of assets. And then once we receive that notification form, we'll send a records request for documents, documents about the transaction, financials, your governing documents. And we'll look at those documents and make sure that there's no big breach of fiduciary duty issue, there's no conflict of interest that's creating issues, that the charity is getting full and fair market value for the assets that are being sold. So we look at all of that. We make sure there are no issues. As long as there are no issues, we send you a letter saying we're closing our file, closing our investigation, carry on. And if there are issues, we let you know immediately to try to fix those issues so that the transaction doesn't close with issues floating around.
So it sounds like all these procedures are an effort to try to continually protect the charitable nature of resources that groups have so that they're not being sold off at unfair prices to someone who's connected with the group and that sort of thing. Is that the general public policy underpinning that these various procedures are intended to protect?
Yes, that's absolutely right. Yeah, we're just making sure that the money is going where they say it is, and that it's going to the right purpose, and no board member, for example, is running away with $100,000 of the charity's money.
And so I'm guessing that just like with the mergers, these kinds of transactions, generally there's a lawyer involved in handling it for the charity?
There is generally a lawyer involved, yes.
Okay. Thank you, Abby. There are a number of organizations that are lucky enough to have pots of money that they can use when times get rough. They may call it a rainy day fund, an opportunity fund, a reserve fund, and some groups have endowments. Could you talk a little bit about what limitations exist out there for charitable leaders when they're looking at a time of financial stress that may be created by this entire COVID situation? What should they be mindful of when they're looking at these reserves of assets that they may have?
Thanks, Beth. Yeah, so it's very important for organizations to know whether the funds that they have are restricted or unrestricted. And typically we're talking about institutional funds that the organization holds. So unrestricted funds are just that, is what they say they are. They're unrestricted. The organization can use them for whatever purpose that it wants, as long as it's supporting the organization. Typically, those have come in through donation into maybe a general fund, a general fundraising campaign. And so there haven't been expectations by the donors that those funds are going to go to a specific purpose. Now, those types of funds are what we consider to be restricted funds. As I said, designated for a specific purpose by the donor. And those those restrictions can come in through, maybe a specific fundraising or solicitation campaign. So right now, as we talk about issues related to COVID-19, a lot of charities have started their own COVID-19 relief fund, with the stated purpose of helping individuals, organizations, groups, whatever, through the challenges that COVID-19 is creating, be that financial, economic, health challenges, whatever. So every dollar that's raised to go to that COVID-19 relief fund should go to a purpose related to that fundraiser. That's a specific restriction. The other types of situations where we see this a lot is where donors give money to maybe their school, their alma mater, with a specific purpose of funding a scholarship or endowing a professorship, a chair, something like that. Well, that money is supposed to be used for that specific purpose. And sometimes there's funds that are invested, and the restriction is that only the income on that trust is allowed to be used for that purpose. So the principle of the trust is not to be touched unless absolutely necessary, or some kind of financial requirement allows it, or something in the trust document actually says that you can go in and invade the principle of the trust. So those are the two kind of main distinctions. You've got unrestricted and restricted funds. And so organizations need to know the difference. They need to know where those restricted funds are, what documents govern those, whether that's maybe a gift agreement by the donor, whether that's a specific campaign and the parameters of that campaign and what that money's going to. So recommend to all leaders to keep good records, always. We always say that, keep good records of of your fundraising or any gifts or endowments or funds that you get. Keep separate accounts. Keep those restricted accounts separate from the unrestricted funds, so you're not commingling that money and losing track of it. And in fact, if you can, keep those separate accounts, those restricted funds separate from one another to the best extent that you can.
Let me see if I
So,
understand straight. So groups could have numerous types of accounts of reserve funds, and some may just be sitting there growing over the years because they just ask donors to please contribute to this growth fund and we will use it when special opportunities arise. And those kinds of funds may have restrictions that the board has adopted, but not necessarily legal restrictions on specifics of how it is to be spent in pursuit and support of the mission. But then other times they may get gifts, maybe large gifts, in which the only restriction could be, I don't want you ever touching the principal of this pot of money that I'm giving you. I want you to do something great with it with the dividends every year. So that would be a restriction on what portion of the money can be used. And then what I'm hearing is there are also restrictions that some donors will make, very specific guidelines about this pot of funds can only be used for scholarships, for instance, or endowing a chair of carbon paper studies or something like that at a university. And so when groups accept these gifts, it sounds like you're saying that they're making a long-term commitment and a pledge of how to use those funds based on what the donor said and his or her intentions in making that gift. Is that correct? Like it sounds as if the donor intention
that's right.
is what rules.
Absolutely, Beth. Yeah. To the best of the organization's ability, you want to maintain adherence to that donor's intent. There's a reason they gave their money to that organization. They wanted it used for a specific purpose. Now, things change over time. Situations change over time. So it's not the be-all, end-all. What was in that donor's will 150 years ago is the only thing that it can be used for. The law allows for modifications or removal of those restrictions due to a change in circumstance. And so I'll talk a little bit about that in a minute, but what I want to touch on a little bit is that in these tough economic times for organizations, charitable organizations, businesses, but in our context, charitable organizations are just trying to stay alive. And they may have this reserve restricted fund out there, and that $10,000, $20,000 is just what they need to pay the bills, pay the rent, pay salaries of their small staff that they've already cut to the minimum. But the organizations need to be very wary that you just can't remove those restrictions yourself. There's a process to that, and that has to be followed to make sure that those funds are being used properly. So I'll talk a little bit. That's governed mostly by statute. Ohio Revised Code, Chapter 1715.55 talks about different ways in which those funds can be unrestricted, either modifying or removing those restrictions. So the easiest way is if the donor is still alive or identifiable, the organization can always go back to the donor and ask them to remove that restriction, and preferably do that in writing. So, for instance, if a big donor gave money for a scholarship or for a certain purpose for a building fund, and it turns out, hey, the only way we can stay afloat is if we use this money, to pay our bills, and that donor's still there, ask that donor. The donor's intent rules when it comes to restrictions. However, a lot of times we see, especially with schools and scholarships, is these things were established maybe through a last will and testament or a trust. Somebody passed away, left the majority of their estate or a big chunk of their estate to create these endowment funds. If that's not available, if the donor is not available, there's two ways to go back and do to change those restrictions. The first is by going through the court process. And in some cases, that's the only way you can change these restrictions if the donor is not there. You're usually talking about larger amounts of money, very specific purposes, things like that. The other way to do it is a notification procedure, wherein there's very specific criteria for the types of funds that can be unrestricted that way. So the fund has to be less than $250,000, older than 10 years, and the purpose that the organization is going to use that money for has to be consistent with the donor's intent. So if it meets that criteria, what the organization can do is, if you go to our website, our charitable section website on the Ohio Attorney General .gov webpage, you'll find a notification form on there. You fill out that notification form with the relevant information. Talks about how much is in the fund, what the fund is intended for, how old it is, what the fund's going to be used for, and you have to send that in certified mail to our office. And basically, it has to be 60 days from the date that we receive that form, that the organization can't basically do that, can't make whatever modification or removal of the restriction. After 60 days from the certified mailing, if our office hasn't gotten back to you, under the law, the organization can go ahead and modify the restriction. However, we will, assuming the mail got to us, we will contact the organization generally to let them know whether we do consent to that removal, or if we need more information, we can ask for another 60 days, and if we object, we can let the organization know that as well. So usually, like Abby said, most of these things tend to have lawyers involved. The lawyers will often contact our office even before they send in the forms, just to get a sense of whether our office might approve that removal, and talk through any issues that might arise in the process.
So I was trying to think of some situations in which an organization could properly request relief from restrictions. And so perhaps someone left behind money to provide scholarships for children to go to a particular kind of camp each summer. And if that camp program no longer exists, the charity can't really honor that intent anymore. Or as I referred to earlier, if you're endowing a chair at a university to provide research on new developments using carbon paper, well, we don't use carbon paper anymore. There are far newer technologies, so it becomes somewhat impossible in some cases to stay true to what the original intentions expressed years ago might have been. So is that what this process is intended to allow?
It can address that. That's right. The statute requires that the intended purpose, in order to remove or modify that restriction, is either unlawful, impractical, or impossible. So, for instance, a lot of the scholarships maybe were intended to go for maybe a certain gender of student or race. Those are not allowed under Title IX of the Education Act for most institutions. So they often ask to remove that restriction on the restricted fund. Like you said, if for instance, the money is supposed to go to fund a certain project, the project no longer exists, that's another impossibility or impractical situation. Now, what the organization should do, assuming it's going to continue to exist, is to use that money in the most similar way that it can to the donor's original intention. So maybe not carbon paper. Maybe we're now, we're looking at other types of scientific developments related to that. Try to keep it as close as possible to what the donor's original intention is. Now, the problem we run into, and that a lot of organizations might see, is if we don't use this money to keep our doors open, there will be no organization left. And so those are the types of situations that we're seeing nowadays, the types of requests that we're seeing nowadays. And, we take those on a case-by-case basis. And we try to do the best thing we can, both for the charitable organization as well as the donor's intent.
Well, it seems as if there's a good reason to want to honor donor intent, because failing to could reduce the willingness of people in the future to make gifts to organizations about something that they're passionate about, if they're able to see a whole lot of examples of gifts from other people being used for all kinds of purposes other than what the original donor was most passionate about. So it seems as if it's an effort to try to demonstrate to future generations that, yes, investing your trust as well as your funds into the activities of charitable organizations should be something that you can feel safe and comfortable in doing. Is that the public policy just that is often being examined?
Yeah, absolutely, Beth. And I think you hit that on the head. And for us as the Attorney General, our job is to protect those charitable interests, protect that donor's intent if they're not there to protect it themselves. So oftentimes, that's why, for instance, that's why those notifications have to come through our office on those specific types of funds. That's why if there's a court, an organization has to go to court to get these restrictions changed, the Attorney General is a necessary party, and one of the attorneys from our section will be involved in that case as well to make sure that it meets the AG's requirements for ensuring that donor's intent is met.
In what kind of court are these kinds of actions filed when charities are trying to look for relief from those restrictions?
Typically, those are filed in the probate court. The law does allow for them to be filed in the common pleas court as well, but the probate court generally handles these kinds of issues, especially if you're talking about something, a gift that was given, a testamentary gift, which means somebody left it in their will or their trust. Those generally go through the probate court. In the county where it can be in the county where the will was probated, maybe, depending on where it is, potentially where the organization is also.
So again, it sounds like there can be a number of procedures and processes that are required, but it's all intended to really protect beneficiaries that the original donor was interested in serving and honoring. And it sounds as if lawyers need to be involved, particularly when there are filings in probate court to seek this kind of relief. So what you're saying is that these kinds of pots of funds that some charities are lucky enough to have aren't going to be the vehicles that they can easily use to plug holes financially that might be created through this coronavirus thing. They need to be very careful about what kinds of money they're using and to assure themselves that it's money that they're entitled to be using for that purpose and not some related to a promise that the organization made in terms of monies that they'd been gifted. Is that correct?
That's right. That's right, Beth. Yeah, it's not often it should kind of be the last resort to potentially use these funds and following the process that I've outlined today, rather than the first option if there's financial trouble.
So do either of you have anything to add about, these are crisis times, unfortunately, in the charitable world, as it is throughout our entire community. We talked about the sad reality that some groups are going to have where they're going to be forced to go out of business. Mergers may end up being the most cost effective and efficient way to go forward with programs. Some may be selling off properties or businesses they may have, and then others may be looking to some of their reserve funds or endowment funds to explore whether any of those monies might present some relief. Anything either of you want to add to this effort to try to just give people a 50,000 feet kind of view of best practice issues to think about in these times?
Well, I would just add, I guess, we are here to help. So in all of these circumstances, transactions, mergers, selling off assets, modifications to restricted funds, these situations in particular are situations where we want to help you. We are here to help you. We are the regulator, of course. We're ensuring that the money is going where it needs to go. We're protecting the donors. We're protecting the charitable beneficiaries. But we're also here for the charities. And in all of these situations, we will help you through the process. You might still need to get outside legal counsel, but we will also work with them and work with you to make this as smooth as possible.
Because we want things to go the right way. When they don't do things the proper way, that can open the door to a lot more unanticipated headaches that, sadly enough, often eat up charitable resources that otherwise could be used for the mission. Probably the best way to reach our office, because many of us are telecommuting for work, is to send an email to our general email address, which is charitable.law@ohioattorneygeneral.gov. And that's charitable law, all one word, at ohioattorneygeneral.gov. Also, if you go to the ohioattorneygeneral.gov webpage and go to the charity section and services for charity, you'll also find our email address there. Matt, do you have any closing thoughts to offer?
I think Abby kind of hit it on the head, Beth. We're here to help. Our job as the charitable law section isn't just to regulate. Our job is to help charities. Our motto is thriving charities, safe giving, right? Well, that's what we're hoping to put out to the sector, that we're here to help and make sure that those charities can continue to thrive. The only other thing I would say is like I said, we will help. If you call us, ask for help. If we can't give you the advice because we're not representing the charity and helping them that way, we can try to point you in the right direction. If your counsel calls us, maybe they're not as well versed in the laws related to this type of stuff. We're happy to work with them to help them to get it done properly and legally.
All right, great. I like to say we're trying to help good people do good things the right way. And so we want to help and point people in the direction so that these things can be done properly, and hopefully conserving the most charitable resources as possible. So I hope some of this has been helpful. Check out the webpage. Consider dropping us an email at charitableLaw@ohioattorneygeneral.gov if there are issues that we might assist in, and keep doing the hard work of taking a look at how your organization is operating, know what its financial situation is and whether there are restrictions on certain pots of money. And we rely on charities in so many ways, and they elevate the quality of our life, but this is a tough time. And only the flexible, the adaptable, and those that are working very hard to be strategic are going to be able to thrive during this process. So we appreciate the work that you're doing, and we wish you nothing but success in trying to provide important services to your communities. So thank you all very much.